Good evening. My name is David Vogel. I'm an immigration lawyer. I host a regular program here on Access Rhode Island Public Television. Some of you may remember me. Was here last month as well. Tonight we have a very special guest. His name is David Borts. He's an immigration attorney in the Providence-Pawtucket line. He's been in practice for roughly 31 years. He has very deep roots in the Rhode Island community. And tonight he's going to be talking about a topic that's on a lot of people's minds: comprehensive immigration reform. Now, by way of background, really quickly, for anybody out there who is an immigrant or connected with the immigrant community, whether they are here legally or not, virtually everybody faces some issues. And we are going to talk tonight about comprehensive reform, because the federal government controls the immigration community and the immigration laws in this country. And we're going to talk about it in a broad concept, or broad spectrum of concepts. And then we are also going to try to squeeze in, if we have time tonight, some maybe common problems that are faced by the community. And if that's not enough time, maybe we'll get him back for a second show. But for that, I'll turn it over to Mr. Borts, and welcome.
Thank you very much, David. I appreciate you inviting me here this evening.
Pleasure to have you. Well, let's start really quickly. You've been in practice for 31 years, right? And you have seen tremendous numbers of immigrants come and go, hopefully stay. I'm sure you've had your fair share of tales. Talk for a minute about some of the problems that are faced by the immigrant community. Let's start with the legal immigrant community. Let's start with people who are facing family immigration issues. What kind of time are they looking at? Maybe some common problems. We'll get to the immigration reform part, but talk about that for a couple of minutes.
Sure. Well, a number of the problems that are faced by legal immigrants and what we call lawful permanent residents right now are the fact and results of many of the common historical problems that resulted from 9/11, also the Oklahoma bombings. There were a number of restrictive statutes and laws passed by the Congress, signed by successive presidents, which placed great burdens on permanent residents just to maintain their status in this country.
That was following 9/11, you mean?
That's, well, and also following the Oklahoma bombing. And
let me explore that for a minute.
Sure.
Was there effectively a change of maybe not legal status, but how they were perceived, and therefore how they were greeted or dealt with by the legal authorities?
Well, there was a change in how they might be removed from the United States after the commission of minor crimes. Okay. That was the strongest and the strictest implementation of what was known as IRA, which was some legislation passed in 1997, which made it significantly easier to remove long-term permanent residents from the United States. It also, over the years after 9/11, much stricter background checks have been imposed. Various restrictions also were placed on members of various Middle Eastern communities in terms of their necessity to report and register with the United States government. In general, there was a great deal of fear common to all of us in this country after 9/11, which resulted in very restrictive legislation, policies, and perceptions as a result of the creation also of a new federal entity, which is the Department of Homeland Security, which brought all of the immigration processes and border protection under one umbrella, so to speak, with the idea that information would be shared. It also resulted in lengthening delays in a lot of the adjudication processes before immigration as a result of the need for collection of more information and background checks.
Well, let me talk about the delays for a minute, because I think that's probably going to resonate with a lot of people who are watching. Prior to DHS taking over, Department of Homeland Security, we had the INS, right?
Correct.
What was a typical wait time for family immigration under the INS versus it's become under DHS, and how's that kind of been affected?
Well, it does vary from region to region.
Okay.
And, giving Department of Homeland Security some credit, there's been a strong effort over the last year to 18 months to improve efficiency in processing. I have seen an increase in the speed of processing, in particular in the local office in Providence, Rhode Island,
okay.
And somewhat so in the Boston, Massachusetts office. Typically, adjustment of status application, which is one where one gets a green card through an immediate family member, under INS perhaps 15 years ago, the process might take anywhere from 3 to 6 months. There was not tremendous amount of documentation required. And now they have finally caught up in the local area to that standard, but up until approximately a year ago, it was taking a year and a half, and there were added delays for any application that was not approved immediately at the time of an interview, where more documentation was necessary. Often those cases were put on a back shelf in terms of review for local examiners to have time to make decisions, or even for the service to want to expedite the process.
So in essence, the length of time now is taking 6 months, 10 months, 12 months?
The local time right now?
Well, not the local, on average. I mean, one of the things I guess I'm asking about, the length of time, maybe not locally, but let's say you live in an area that's congested, really congested, Miami, Florida, San Diego, California, Austin, Texas, Dallas. What kinds of increases has there been from INS over to DHS?
Lengthy delays. I mean, there were periods there were periods of time where petitions were taking in Miami were taking 2 and 3 years, and the same in some other larger urban areas.
As a result of DHS taking over from INS, has there been, let's say, more stringent examination of the applications? In other words, are people getting denied who might have been accepted under the INS either for good reason or maybe no reason at all? How difficult has it become?
It's become much more difficult. One of the things that has been very common is under DHS and Homeland Security, the applications are read with a fine-tooth comb for contradiction. Applicants who don't have counsel are at risk. The tendency is for Homeland Security adjudicators, in my opinion, to conduct a much more stringent interview than when counsel is present.
Let's talk about that for a minute. You just said something that is extremely helpful, I think. When we were talking off air before the interview in your office, you had mentioned a couple of pitfalls that people fall into regarding when you just said the applications are gone over with a fine-tooth comb. Talk to the audience for a minute about some of the things that can happen that will trigger maybe a rejection or a request for evidence, an RFE, or something that will essentially make the examiner look at the applicant and say, I'm sorry, you just don't measure up. And the applicant is sitting there scratching his or her head saying, how did this happen?
Well, a couple of the situations that I've run into over the previous year, one is that an examiner who feels that there's not substantial evidence in a file may start actually asking questions of the American citizen about their background. Technically, that's not germane to the interview. However, it may be considered germane.
That's in a marriage application.
Right, in the marriage application, may be considered germane and relevant to the issue of credibility. In other words, has an American citizen petitioner disclosed to their foreign-born wife or husband that they had a criminal record? And that is.
And this is relevant for the American.
Well, while the American faces no deportation potentially, but what may happen is if they haven't disclosed to their spouse that they have a criminal background, there'll be this moment in an interview of aha, so you don't know. And it can be used to try to get at the credibility. And once you get to credibility, then the examiners will start attacking what they call the bona fides of a marriage. In other words, is the relationship real? Now, the other area, which we did talk about at some length the other day, is one of the things that may bar somebody to becoming a permanent resident of the United States, which is not well known. If you at any time in your stay in the United States have declared yourself to be a United States citizen to obtain an immigration benefit or any other federal benefit,
which is pretty broad.
It's pretty broad. You can't get a green card.
Talk about some of the ways that you can inadvertently do that. So you had a couple of wonderful examples, and I'd love you to share it.
Sure. These days, everybody needs to support their family. Times are tough. Tough for people born in the U.S., tough for foreign-born persons, even tougher for people who can't show documentation to work. And most of them don't have the wherewithal to return to their country, or if they did, couldn't survive. So the typical person walking into a medium to large size company now, applying for a job, if they're offered a job, will be asked to fill out something called an I-9. An I-9 is a form that's required to be kept by each employer in their files that documents the fact that they have examined the worker and they are sure that they're eligible to work in the United States. If you do not have that documentation and you need a job, the first question is, are you a United States citizen? If you answer the question affirmatively, and there are many people now who've been in this country long term who may not even have accents or appear to be foreign born because they came here when they're 5 or 6 years of age and have been here for 15 or 20 years.
They've been brought up as Americans.
Right, exactly, brought up as Americans. It's very common for those people not even to appear to be foreign born. If they say US citizen, they're hired. Probably if they have a driver's license or a social security card.
Well, okay, how would they obtain a social security card if they were never citizens to begin with?
Well, many years ago, it was easy to obtain a social security card.
Okay.
Many people have them. There are people who in the distant past had parents who may have filed an application for some benefits of which their children were dependents. They might have gotten a social security card that way.
Was that based upon the child being born here?
No, that was based upon perhaps an application for political asylum, an application for something called NACARA benefits. Any type of application might have been filed, and a child may have been eligible up into their 21st birthday to obtain a work authorization based upon their parents' petition, as well as a social security card. So they may have a social security card.
Okay, let's say in the case where they don't, they're 27 years old, walk in, like a job, they were brought here when they were 4. They've never actually held a green card. They've never actually been a citizen. They don't have a social security card. Are you a US citizen? I think so. Yeah, great, you're hired. But how do they get hired?
They get hired because the companies need the workers. Very simply. Now, the employer is actually violating the law.
Okay.
However, the undocumented or illegal, as some people would call them, does have to sign the application. And they sign the application that may have been filled out by the employer, perhaps not even knowingly. The new employee may sign the application. And if they go to an interview at immigration and have listed their employment, as they're supposed to do on a number of applications for the previous 5 years, and if they give the answer that they are working, and if the examiner decides to check the I-9, the I-9 will come back from the employer saying that they're a US citizen, at which point the application for permanent residence will be denied and the person will be referred to the deportation court.
What are their options at that point?
Their options at that time do exist, but they are only possibly eligible for something called cancellation of removal, which is something we've had a lot of discussion about. We may talk about in some other areas, but they are potentially still able to make a claim for cancellation of removal, which requires proof of residence for over 10 years, good moral character, and an immediate relative who's a U.S. citizen or a permanent resident who would be harmed.
A hardship.
If the foreign-born person was removed or deported from the United States.
As I understand it, generally speaking, the hardship waivers are pretty high standards.
The standard at cancellation is exactly extremely unusual hardship.
And what is an extremely unusual hardship?
Well, in examples of...
Have you ever won a case on that?
Yes.
Okay, good. Share that, please.
I'll give you an unfortunate examples.
Okay, please do.
Children with leukemia,